Today is August 25th, 2021. My name is Rob Carr of Kalamazoo Right to Life, and this is Pro-Life Week. Well, don't get me started about Joe Biden and his absolute fiasco in extracting our soldiers and personnel and citizens and our Afghan allies out of Afghanistan. You know, we practically are capitulating to the Taliban, a terrorist organization, on getting our people out. An absolute humiliation for the United States. But today I want to talk about two different things. One is the Supreme Court announced several months ago that they were going to hear a case coming out of Mississippi. Mississippi passed a law prohibiting abortions after the 15th week of pregnancy, which is in violation of Roe v. Wade and Planned Parenthood versus Casey, both of which basically demanded that no state could enact any reasonable restriction on a woman's right to choose an abortion before fetal viability, which obviously has been going down because of modern technology and advancements in medicine. You know, back with Roe v. Wade, viability was considered around 27 or 28 weeks. By Casey, it was down to 24 or lower, and today many babies are delivered at 20 and 21 weeks that survive. So clearly viability is a fluid issue, and I would argue it's an arbitrary benchmark, not based on scientific reality or medical reality. Anyway, the Supreme Court's going to hear this case. And as the lead up to the oral argument, pro-life organizations have been submitting friend of the court or amicus briefs by the dozen. I think back to the Casey decision, where most of the amicus briefs submitted to the Supreme Court were filed by pro-abortion groups. Now, there were several pro-life groups, but the majority back then were pro-abortion friends of the court briefs. They were completely convinced that the court was going to reverse Roe, so they put in a deluge of amicus briefs to help sway the court their way. And perhaps it worked because Casey really went their way. Well, here we are, it's 2021, a new case coming out of Mississippi, and pro-lifers have been submitting amicus briefs like crazy. And I would have to look at my computer here to help me along, because I don't want to miss. But I've got a list of some, not all, but some of the organizations or individuals who have submitted briefs. And it's kind of like a who's who in conservative or pro-life circles. We have the National Right to Life Committee. We have the Catholic Medical Association, the National Association of Catholic Nurses, Senators Josh Hawley of Missouri, Mike Lee of Utah, and Ted Cruz of Texas submitted a brief. The Thomas More Society, the Becket Fund for Religious Liberty, U.S. Conference of Catholic Bishops. Our friend from Bronson Hospital, Robin Perucci, Dr. Robin Perucci, a neonatologist at Bronson, submitted a brief along with, where is it now, the Life Legal Defense Foundation. Thank you, Robin, for that. Thank you. Priests for Life, the Center for Medical Progress, and David DeLyon. He's the guy that submitted those Planned Parenthood videos about 4 years ago, and he's being taken to court. The Christian Legal Society, Concerned Women for America, Lutherans for Life, Americans United for Life. Our friend from Americans United for Life, Clark Forsyth, who wrote this book, Abuse of Discretion. He's the principal author of this friend of the court brief. Let's see. Ethics and Public Policy Center, Pennsylvanians for Life Federation, the Family Research Council, a division of Focus on the Family. Professors Marianne Glendon and Carter Sneed. Marianne Glendon is a strong pro-life law professor from Harvard Law School. Care Network, a national affiliation of 1,200 pregnancy care centers. Illinois Right to Life. The National Catholic Bioethics Center, the state of Texas. Ben Carson submitted one through an organization called the American Cornerstone Institute, Democrats for Life, the American Association of Pro-Life Obstetricians and Gynecologists, the Susan B. Anthony List, Judicial Watch from Tom Fenton, the Charlotte Lozier Institute, which is a division of the Susan B. Anthony List, American College of Pediatrics, the Heartbeat International, March for Life, Education and Defense Fund, Texas Right to Life, the American Center for Law and Justice, which is Jay Sekulo's group, Billy Graham Evangelistic Association, and the last here that I want to mention is Joseph Della Penna. And he was a law professor at Villanova for many decades, and he wrote a book back in, I believe, in 2006 called Dispelling the Myths of Abortion History. It's about a 1,000-plus page book that destroys the pro-abortion argument that abortion was a long enshrined fact of life in colonial America. The women were enjoying the right to abort in 1810 far more than they were in 1910. And he destroys that with scholarship and research and thousands of footnotes, going back to British common law, going back to the 12th century. Anyway, we are sending these briefs to the Supreme Court and hoping and praying and believing that the Supreme Court is going to look at this Mississippi case, look at Roe v. Wade, look at Casey, and realize that Roe was egregiously wrong in its original ruling, and it's time to throw it out. And we're just believing that these Friends of the Court briefs will play a big role in educating the court, the justices, the right way. And we're believing that President Trump's three newest justices, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, will look at the evidence and make a new decision on abortion policy in this country and rule in favor of the Mississippi law. And the second point was back on August 18th, just a few days ago, when the Fifth Circuit Court of Appeals in the Texas area ruled that the Texas dismemberment ban was constitutional. Now that's a big case because a lot of states have passed dismemberment bans, but they've all been blocked by federal courts. Well, now we have a federal, an appellate court. They ruled, I think it was 9-5, that the law was constitutional. So we may have another case going before the Supreme Court dealing with dismemberment abortions because it deals with the D&E abortion procedure. And, going back to the Supreme Court with the Mississippi case, it's very possible that even if the court may rule in favor of the law, they may not completely dismantle Roe. It may be that they're going to chip away case by case. And it's possible that they may take the Texas case as another example, and perhaps they're going to take a heartbeat case, another one out of Texas, and ban abortions after 6 weeks, which basically would completely nullify Roe v. Wade. So I'm going to leave you with that. These are exciting times, and the Supreme Court may be hearing the Dobbs case sometime in October or November, and we would expect to see a decision sometime in the spring of 2022. With that, thanks a lot. See you next time.